Right, we have a quorum and we've reached the appointed hour. The meeting is now called to order. This is the Bills Committee on Inland Revenue Amendment Number 3, Bill 2015. Election of Chairman. Please nominate a candidate. Mrs. Sin Chung Kai, I nominate Mr. Kenneth Leung. Do you accept the nomination, Kenneth? Any seconder? Any seconder? No? If there is no seconder, okay, I second. Mr. Dennis Kwok seconds the motion. Do you accept the nomination? Yes, I do. Any other nomination, please? No. Okay. Then Mr. Kenneth Leung is the chairman of the Bills Committee. Please take the chair.
quorum 幾人㗎呢個 ？quorum 3個，係咪我？咁咪冇需要選舉副主席，可能冇需要。好啦，
Do we need a vice chairman? If not, then we just move on. Okay. Let us invite the officials into the room. I believe you have the names of the officials in front of you, so I'm not going to introduce them one by one. I'd just like to ask members whether you'll be in Hong Kong in September. In September, say early September, will you be in Hong Kong? No. Mr. Mok and Mr. Kwok will not be in Hong Kong, so will be in Hong Kong. So, well, I have difficulty. Mr. Sin said. Do you accept video conferencing? All right. Good morning, ladies and gentlemen. This is the first meeting of the Bills Committee on Inland Revenue Amendment Number 3 Bill 2015. I'd invite officials to introduce the bill and the policy objective. Yes, Mabel, please. Thank you, Chairman and members. Good morning. The Inland Revenue Amendment Bill is to enhance the tax appeal mechanism and to improve efficiency and effectiveness of the Board of Review so that we can help the appellants in respect of reducing the time and costs spent in the appeal process. The proposals have been supported by the Board of Review and also the Judiciary. Let me turn to the areas of improvement. There are 4 of them, broadly speaking. The Board of Review is a statutory board which is responsible for hearing tax appeals. There are 4 areas of proposals under the amendment bill. Number 1, allow an appeal against a decision of the board on a question of law to go direct to the court of first instance. At present, under the Inland Revenue Ordinance, the appeal has to go through the case-stated procedure. And the Board of Review will have to deal with the appeal, the process, and a hearing may be involved, and legal documents will have to be prepared. Therefore, it is very costly, and this has therefore indirectly slowed down the process of handling the case by the court, and this will also bog down the Board of Review's work. Our proposal is to follow the example of other tribunals and boards, and that is to cancel the case stated procedure, so that any appeal against a decision of the board in respect of questions of the law can go directly to the CFI or the Court of Appeal, or CA in short. The appellant or the director of Inland Revenue can apply for leave from the court, and then the court can hear the case. The bill also retain the leapfrogging arrangement, so that when it is fit in the mind of the court, the appellant can go directly to the Court of Appeal, even though the case stating requirement is taken away. We've also made reference to the practice of other tribunals and appeal boards, so that when people are called to produce evidence or to provide documents, directions can be issued. If the parties concerned do not comply with the directions, and then there can be sanctions imposed. In order not to cause unnecessary financial burden on the appellants or unnecessary criminal sanctions, our proposal is that if the parties concerned cannot comply with the directions of the board, then the document or the evidence will not be accepted. There is also a provision in the bill to allow the aggrieved parties to seek remedy. Say if the presiding officer is of the view that there is a reasonable defense, the sanction will not be imposed. If I may move on to the third and fourth areas. They are the technical aspects in respect of dealing with appeals. In respect of the chairman, deputy chairman, and also members of the board, there is no clear provision in respect of the privileges and immunities given to them. But such privileges and immunities are very common to similar boards and tribunals. This is to ensure that there will be no unnecessary risk of litigation. The board, under the IRO, is given the power to deal with the appellants in which the assessment can be reduced or varied. But if the appeal is rejected, then the board may have the power to deal with, say, abuses and by way of imposing costs on the appellant. At present, the ceiling of costs is $5,000, and it has not been changed since 1993. We have received a very strong indication from the chairman and vice chairman of the board that it is time to make a suitable adjustment to increase the deterrent effect of the costs. And we propose to raise this, but our proposal will only recover about 30% of the cost. We believe it is a reasonable level, and it will also not deter anyone aggrieved by the tax assessment. We have consulted the Board of Review. We've also consulted the judiciary, and we have obtained their support. As for the details of our proposal, they are all contained in the legislative brief issued to members in June. Thank you. Well, I have to declare interest. From 1999 to 2008, I was a member of the Board of Review. I'll now open the floor to members. A show of hands, please. Mr. Sin. Is there a page number? Yes, I think page 5. Paragraph 16, rather. A strengthening deterrent effect against frivolous tax appeals. Without such powers, how many frivolous complaints, frivolous appeals have you received? Was it 21%? What is the difference? Say, with the increase in appeal, how many cases can be deterred? Well, all the way there is this provision of awarding of costs, and in the schedule, it is said that the SFST has powers to amend the cost by negative vetting. But we just want to make an amendment together with the bill. In the past 5 years, on average, 43 tax appeals per year, and only 9 cases were awarded costs. We found that the appellants, some of the appellants, did not file complete and accurate tax returns, and some had repeated offenses, or rather they made repeated appeals. The facts showed that they abused the process. The ordinance impose a cap on cost, and it is up to the board to decide whether to impose a cost on the appellant or not. About 60% of the 9 cases were awarded were required to pay up to $5,000, and the remaining were required to pay up to $3,000 or $4,000. A few $1,000s is not a deterrent. They spend a lot of money to file the appeal. They don't need to, they have to go through a very complicated process. Well, the law allows such a right to make an appeal. The spirit of imposing costs is in respect of the efforts and time spent on hearing the review and preparing for the review. The chairman, the vice chairman, the members will have to attend the meetings, and the cost of preparation is very high. And as for each case, it may cost about an average of $80,000. We are not to recover cost, but if we look at other tribunals or boards, it is very common to give them the power to impose costs on the appellant. This is They look at the actual costs, and then they also consider whether there is any abuse or any repeated offenses before they award the costs.
The board also considered that a ceiling of $5,000 as compared to the costs involved in the cases, the proportion is still very low. So if we should suitably raise it to about $25,000, and if we're going to recover about 30% of the cost, then we hope that there will be sufficient deterrent effect. Of course, we do hope that in future we would have a mechanism for a regular review of the costs and to see if it is really having a deterrent effect. Thank you. Mr. Sin? Well, I don't want to say that you haven't really answered my question, but what I'm trying to ask is that your cost right now is about $80,000, and you want to raise the ceiling from $5,000 to $25,000 so as to increase the deterrent effect. But my question is, well, maybe it's just a guesstimate on my part, but to me, I'm not very familiar with this subject. So actually, what are the frivolous cases that we're talking about here? If they are frivolous, that means their chances of succeed are low. So that's why you want to raise the cost so as to deter them from committing the same case or mistake again. So maybe the appellant is aware that they don't have a high chance of succeeding, but still they go for the appeal. So I'm just wondering, what are the advantages for the appellant to do so? Or do they have other objectives? Well, thank you, Mr. Sin. Let me try to answer you this way. I think the mechanism for the Board of Review is to allow the applicants to lodge reviews against the Commissioner of Inland Revenue. So maybe it's about profit tax or salary tax or additional tax. So they're appealing about the amount of the above taxes. But they have to prepare for the appeal. They have to put in a written application, and they have to put in the review, and they can invite legal representatives or taxation representatives, or they do it by themselves. And recently, we see that a lot of appellants are doing the appeals just by themselves. Of course, I cannot guesstimate the reasons for their lodging of the appeal, but I would say that this is not a very complicated or expensive appeal mechanism. So the objective is to allow the appellant a channel or a right for them to lodge an appeal. So maybe the appellants feel that they do not agree with the Commissioner's decision or his assessment. That's why they go for an appeal. So this is the first objective. Secondly, I think the board can either reduce or annul the amount decided by the Commissioner. So we think that the appellants may want to make use of the appeal mechanism to see if the assessment can be reduced or removed altogether. So there is a chance for them to raise the case. Thank you. Mr. Sin, any further questions? I'll go for the second round of questions later. I would like to ask Ms. Chen, do you have recent statistics, say, for the past 2 or 3 years as to the cases handled by the board? So which side wins more? I mean, the appellant or the board? Do you have such statistics? I think when we go back, we'll try to collate the statistics and provide to this committee. I think there is not any particular trend, but I think having received the cases, then they may not all be processed within the year that they are received. So the decisions from the board would take some time and may be granted the year after or announced later. So we would need to take time to sort of, coordinate or collate these statistics. So I do not want to sort of make a guesstimate here as to which side wins more. Well, I noticed that the chairman or the deputy chairmen of the boards are mostly legal practitioners, solicitors or counsel. So they must be very busy people. So on average, after the hearing by the board, is there a requirement for the chairman or the deputy chairman to sort of produce the results of these decisions within a particular period of time? Is there such a requirement? Well, Chairman, to answer your question, the chairman or the deputy chairman of the board are part-time people. They are not working full-time for the board. Majority of them have legal training. Some of them may have different training or background. So they all have busy schedules. And the cases, some of them are easy and some of them are more complicated and complex. So in the ordinance, we do not have any particular requirements specifying the period of time that they have to complete a case. But I have some statistics which show that in recent years, on average, in handling the appeals, I think the average time is, as stated in the paper, involves 3 sessions, and every session means a half day. So there's an average of about 1/2 day to 1.5 days. But for the simpler cases, maybe they can be completed within half a day. But for the more complicated cases, they may have to be considered for about a week's time. So this is the period for the hearing. But then, of course, the time taken to reach a decision on the case will depend on the individual circumstances. And it may take 1 to 2 months or to even 3 months. Thank you. Mr. Dennis Kwok? Chairman, I know that we haven't entered into the clause-by-clause session yet, but I have a question on 169AA, Section 1B. It is stated there that the CFI must not receive any further evidence. So I want to ask, why are we being so specific here? It seems that it should have the discretion to decide when the CFI would do so and accept new evidence. So I want to ask whether we should give the discretion to the judiciary or the judge according to Lord and Marshal rule. Because, in some cases, the evidence may be for some unknown reasons or due to some special circumstances is not available to the appellant. And it is only until that the case has reached the CFI that the evidence becomes available. So under such circumstances, are we still debarring the CFI from considering this information? Well, thank you, Mr. Kwok, for this question. We have actually consulted the judiciary on this and seek their views. This provision is actually raised by the judiciary, and we have also made reference to the rules of other tribunals. It is stated here that either the CFI or the CA, when they are dealing with the grant application for leave, they will say that the Board of Review have made some decisions, and some of them involve the points of law, and then the appellant can appeal to the courts. So it is on this basis that the judiciary has agreed that they want to follow the existing practice of the high courts, the similar provisions of other tribunals, say like the Labor Tribunal or the Small Claims Tribunal. They all have similar provisions, which stated that they cannot admit further evidence or facts. But if we look at Section B2 here, we have also consulted the Civil Division and the Judiciary, and we have added that if the CFI has ruled that there is erroneous situation concerning the point of law, then they can have an exceptional arrangement. We have also added that the CFI, if having considered the conclusion, they can remit the case back to the Board of Review and give them directions so that the board can handle the case again or hear the case again. So there is a division of work between the two. So in terms of the collection of evidence and facts, that will be reverted back to the Board of the Review. And there may be another judgment based on the facts. Well, I'm trying to look at it from the point of view of the judiciary, and I understand that they want to simplify the hearing, and they do not want to have further argument about the facts. But from the point of view of the appellant, if they have very important additional facts or evidence, which is not available to them until the case reaches the CFI, then you are not allowing them to submit such evidence, and the court cannot accept this evidence. This is a very definitive decision, and it may create unfairness. I think you can't just look at the case from the point of view of the judiciary, but also from the perspective of the appellant. So I don't understand why not for B1 you cannot allow the court to consider the new evidence. For B2, I still don't quite understand how it operates, but let's put aside B2. I just want to go back to B1. Can you take the existing mechanism and allow the letter marshal exception applies so that there will not be strict rejection to consider further evidence? Well, thank you, Mr. Kwok, for your suggestion. I want to point out that in the amendment bill, the amendments have been adhering largely to the Board of Review and the powers of the board as the basis. At present, in the ordinance, the board is empowered to consider appeals concerning points of facts only. So they have the final decision on the facts. And this is stated in the existing ordinance. And if there are questions about a point of law, the current spirit is that these cases, if the appellant is appealing about, questions concerning the point of law, that will be referred to the courts, and the High Court rules will be followed. And that means they will not receive any further evidence. So this is raised by the judiciary, and the judiciary hope that for the amendment bill, we will try to clarify the situation and stand alone here in the amendment bill so that there will be some comprehensiveness here. Well, maybe I'll try to supplement. I think the function of the board, as Ms. Chan has said, is only for fact-finding. That is its primary role. So it is maybe 3 to 6 years, after the case has been happened, and then it will be put to the board. So there is actually sufficient time for the appellant to collect all the evidence or the witnesses available. So as Ms. Chen has said, the taxpayer in most cases will try to lodge the appeal themselves, but then there are also other cases which I have come across that either the TsyB or the taxpayer have solicited London sales. I think that has happened. I think that case involves the bank. The taxpayer is a bank. So, Mr. Sin, do you have a second round of questions? Yes, I have a question on the appendix. Looking at the some 40 cases handled in the past years, you haven't told us how many cases are successful or not. Can you explain to us a bit more about the cases handled in the past 5 years? How many cases are successful? Chairman, I think from the point of view of the appellant or the commissioner, they can both lodge appeals. So we are not just talking about, members of the public here as to whether their appeals are successful. But maybe I'll ask Mr. Tam from the department to, do you have the information readily available with you? Mr. Tam? Sorry, I don't have the detailed statistics with me now, but we can supplement the information later. Mr. Sin, any further questions? Can I have a few questions about the administration of the board? Right now, the chairman, we have 1 chairman and 9 deputy chairmen. I want to ask whether all the vacancies have been filled. So all 10 places have been filled?
Yes, Chairman, if I may add, at present, the chairman and vice chairman have been, or deputy chairman have been appointed. As for the deputy chairman, we have not appointed all of them up to the limit set by the law. The number of vice chairman or deputy chairman are able to deal with the work, or cope with the work. And in case there are suitable persons to be appointed as the deputy chairman, we will appoint more so that more can be involved in the work of the Board of Review. How many members are there? And what is the statutory limit? 150 altogether. and we have appointed 50 of them. Since you only have 50, is the workload very heavy? You need 2 members present at the hearing. What is the average number of meetings to be attended by each member per year? Yes, Chairman, there is a heavy workload. In 2010, or even earlier, there were 50 or 70 cases. In recent years, the number has stabilized. It's about 40-odd cases. But the complexity of the cases has increased. As for chairman and deputy chairman, the number of the hours of hearing is very high. As for members with legal background, they will have to spend quite a lot of time on the work of the board. And we are seeking to appoint more members. We have a regular mechanism in respect of appointments. We issued invitations to more than a dozen organizations, asking them to nominate their members to be members of the board. We are doing it every year. Mrs. Sin, do you have further questions? I just want to ask the Permanent Secretary. My impression is that you have already discussed it with the Joint Liaison Committee on Taxation. I think you raised it 4 years ago. Apart from the Board of Review and also the Judiciary, do you or have you talked to other stakeholders, mainly the JLCT, as you said? The JLCT is widely represented. It has members coming from the legal profession, the taxation profession, and other professions. Now, the present proposal is rather technical and procedural. So the main consultation is with the JLCT to seek the views of the parties concerned. Do you have anything attached to our paper in respect of the JLCT's view? As far as I can recall, there were 2 discussions with the JLCT, and it supported the general directions of the proposals. We've mentioned that. As for the JLCT's documents, we have not attached them to the paper. But will you ask the JLCT if the JLCT can provide its view to the Bills Committee? Maybe we can write to them. Do members have further questions in respect of this bill, the general policy direction of this bill? I just want to know whether members would like to call a public hearing in respect of this bill. Mrs. Sin, I don't think there is a need to have a public hearing, but we can put some information on our webpage and say that we have this bill and we welcome comments. If they are asked to speak before us, then they will be allowed. Otherwise, we may not need to have a public hearing. All right. Let's write to the professional bodies, including the JLCT, to seek their views. And if they ask for a hearing, then we will invite them to come. As for the progress of work, I know that the Financial and Financial Services Bureau has another important bill to work on. Well, depending on members' schedule, depending on your summer vacation, I hope that we can have another meeting in September. And if no deputation asked to be had, then we will proceed to clause-by-clause study of the bill. So the meeting is now adjourned. Thank you very much.